Good afternoon, and thank you for joining us for this Law for Community Worker webinar, supporting clients who are exposed to the care and protection system, how community workers may be able to assist. Before we begin, we would like to acknowledge the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the lands of the Widjabul people of the Bundjalung Nation. We pay our respects to the elders of the land, both past and present, and also extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. So welcome, my name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. Today's webinar will run for 1.5 hours. We've extended it the time for this webinar from when we ran it last year to make sure that there's enough time for questions and answers and to get through the content. After the webinar, you will receive an evaluation survey, and we do appreciate any feedback and take on board any suggestions for other topics that you'd like to hear about from us. Now I'll introduce you to your presenter, Daniel Kennard from Legal Aid's Family Litigation Team. Thanks, Daniel.
Thank you so much, Bridget, and thank you to everyone who's participating in this webinar. 1.5 hours is an extraordinarily long period of time for people to concentrate, and so there's no expectation that you'll concentrate for the whole lot of it, and I'm hoping that we might take a break at some stage in the middle. And if you need to come in and out of the webinar, just do so, because it's just a lot of time and a lot of effort for people to concentrate for that long. I'm coming to you from the people of the Gadigal Nation, the Gadigal people of the Eora Nation, which means I'm in Sydney. I noticed that someone was beaming into us from, I can't recall the name of the nation, but from Ballarat. The law that we're mainly talking about is New South Wales-based law, and so the information that I provide to you may not be exactly accurate to the Victorian system. In fact, it's unlikely to be. However, perhaps some of the approaches and some of the information would be a helpful way to deal with your clients in your role as a community worker. I'm really delighted to present this webinar to people because I am a care and protection solicitor who works in Sydney and has worked in the regions in New South Wales. And part of my joy of my job is working with parents who've had their children removed. And part of the joy in that role is to work with community agencies who are providing services to parents. And part of our thought process in providing this webinar was to think about how we could mostly support community workers to help those parents or the children to whom they're providing services to meet the needs of those children and those parents as they navigate a really difficult and confusing system. And so one of the things I thought before we began to talk about the law and what we're going to do is just to think about what child protection looks like from the perspective of different people who participate in the system, because in my experience, each person, of course, has a unique view in relation to what child protection is. But generally, if we think about child protection from the perspective of the parties or the participants in the system, we may be able to gain valuable insights that assist us as lawyers and you as community workers to deliver services to the most vulnerable and the most needy members of our community. So for parent clients, they're parents whose children have been subject to investigations. Child protection is probably most likely about the government or a non-government agency now telling them that they are bad parents. The information they're getting from service providers with respect to child protection issues when they come into contact is that they are not doing the right thing, or they are not good enough to provide care to their children so that their children are safe. The child protection system for parent clients, I would suggest to you, is really seen by those clients as being a system about them and their parenting and their deficits. It's a system that may reinforce their experience of the world as an unfair place, as a place that is unjust, as a complex and difficult place to understand, and a place that it's unsafe for them to communicate their true feelings and concerns because there are large risks for them. One of those risks may be that their children are removed. Could we go to the next slide, please? As workers in the child protection system, and that could be lawyers, it could be service providers, it could be the Department of Communities and Justice, we see the child protection system as a system that's about children. We see it as a place where children's needs are met, and the focus of the system is to provide care and protection to children to ensure that they are able to meet their potential. The system is, in our mind, protective and future focused, and also a system in which we say there is some moral imperative for us to do the right thing to ensure that children are safe, because if we don't do it, then how are we going to ensure their safety? One of the issues with respect to a worker's moral imperative is that in many respects, it is a permission slip to do things which otherwise they would not have permission for. Now, this is not something that it belongs to the worker, it's something that belongs and is embedded in the law. So, for example, children who are in contact with the child protection system are able to have, or workers working with children in contact with the child protection system are able to access information about those children and their families if there is concern that those children are in need of care and protection. That information can be provided by a number of agencies who work for the government, including the police, the Department of Education, and the healthcare system. So parents who are engaged in this system may not be aware that the Department of Communities and Justice, and indeed other agencies working with children in need of care and protection, have accessed personal and private information about them with the view to assessing risk. There is no issue, and I'm not challenging the right of government agencies to assess risk, but from the perspective of a parent, it is quite intrusive. And from the perspective of a worker, it is justified. So there's a tension between the moral imperative of a worker or a person in the child protection system to ensure that children's safety, welfare, and wellbeing is met, and the experience of a parent in that system in relation to the intrusion into what they would consider their private life. If we could go to the next slide, please. So the child protection system, as workers may know, is not just a state-based system and is not just related to Australia. Part of the foundation of the system, although child protection legislation has been around well before the United Nations Convention on the Rights of the Child, but part of the foundation of the system comes from our international obligations with respect to the International Convention on the Rights of the Child. Now, some of those articles that are worth workers being aware of include Article 3, which says that all organisations concerned with children should work towards what is best for each child. So the focus is on individual assessment and understanding of children's needs. Article 9, which says children should not be separated from their parents unless it is for their own good. For example, if a parent is mistreating or neglecting a child, children whose parents have separated have a right to stay in contact with both parents unless this might cause harm. So these are summarised versions of the articles. Article 19, which is governments should ensure that children are properly cared for and protect them from violence, abuse, and neglect by their parents or anyone who looks after them. Article 20, children who cannot be looked after by their own family must be looked after properly by people who respect their religion, culture, and language. Articles 32 to 36 speak about the way that government has an obligation to protect children from harm arising from health or drugs or sexual abuse or other issues that children might be exposed to. Article 39 talks about children who've been neglected and abused should receive special help to ensure that their needs are met. And Article 41 says, if the laws of a particular country protects a child better than the articles of the convention, then those laws should override the convention. So of course, it's an international instrument which is aimed at providing protection to every child in the world, and of clearly some laws in some states are going to be superior than the compromise position available on an international instrument. In New South Wales, there are a number of laws that relate to child protection and the care and protection of children. The primary legislation, and the legislation that I'll almost exclusively be talking to you about, is the state-based Children and Young Persons Care and Protection Act 1998. In some respects, this is the act that parents may see as regulating their parenting. It's the act that the Department of Communities and Justice, which used to be known as Family and Community Services, which used to be known as Department of Community Services and other iterations of the name, has legislative authority to investigate and manage risk for children, including the right to remove children from parents and assume legal rights, whatever they may be, and I'll talk to you about those, legal responsibilities from parents to make decisions in the best interest of the children. There are also other acts that relate to child abuse and neglect, including the Crimes Act. There are acts which regulate the way that people work with children with a view to protecting children. And that last act, which says Statutes of Children Act, should be the Status of Children Act, which also talks about children's rights and the responsibilities of the state to protect children. The act that I'll be focusing on, as I've said, is going to be the Children and Young Persons Care and Protection Act, but just be aware that there is a landscape of other state-based legislation that relates to children. All right, if we can go to the next slide, please. Today, what I'm hoping to cover is how the care and protection system works in New South Wales by looking at it through four different ways. Firstly, early intervention. So exploring how community workers can work with the system and with parents before the court's involved. There are some changes to the law that I'd like to talk to you about, which are now historic changes in a way. They came about approximately a year ago. How community workers can support parents and children when the matter's before the court, and what options are there for parents and children once the case is over. Early intervention, of course, is the focus of everyone's desire and view, because people share the position that if we can intervene with families before it gets too damaging, that's obviously going to have the best result in the best outcome for a family and their child. All right, we can turn to the next page. Today's focus will be on our client and your role in providing assistance by looking at the law, some issues about evidence, not much, but a little bit, talking about when and where to access legal advice and support for your clients, and just some really practical things that you might be able to do for your clients that will help them navigate what's a really challenging system. I should say, my assumption is that you are working with clients who have contact or are at risk of having contact with the care and protection system. And my other assumption is that you're working in a variety of fields, including legal and non-legal fields, to support clients and their children. This information can be used in any case, but it might be, that's the focus of this talk, in the hope that we can navigate the system together to achieve the best outcomes possible. This is not an opportunity, as far as I'm concerned, for me to be critical of the legislation or the government systems that are in place to support families. That can be a discussion that you may wish to have, and it can be a discussion that has validity. But in this forum, it's really about using the systems rather than challenging them to get outcomes that are best for children and families. If I can go to the next slide, please. So one of the fundamental issues that requires that community workers should be aware of is that there's a very big difference between the care and protection law and system and the family law and system. So, and if we have a good appreciation of the differences of those systems, we might be able to think of options where we can navigate a client out of the care and protection system and into the family law system, if that's appropriate and is what the client wants, giving them sufficient agency in that decision. So the family law system, and when I'm talking about the family law system, I'm primarily discussing the Family Law Act, and I'm primarily here, actually here, discussing only the aspects of the Family Law Act that relate to parenting, and not those aspects of the Family Law Act that relate to the distribution of marital property, or those aspects of the Family Law Act which relate to divorce. They're all there. There's also information there about Australia's international obligations under the Hague Convention. But that's not the issues that I'm talking about. So generally, for most participants in the family law system and most people who you may come into contact with as your clients, family law is about resolving disputes between parents or people providing care to children. It's about two parents saying, we can't agree on what is best for our children. We can't resolve that dispute without the assistance of a legal process, and we are using that legal process to resolve the dispute. It is generally a voluntary process, and of course there are going to be times when a person is joined to the proceedings even though they don't wish to be because they need to be bound by an order. It can be resolved by consent, and yes, it's true that every consent order needs to be considered in light of what is in the best interest of the children, and there's a test contained within the Act which any consent order is subject to. It can generally be stopped once it's started. So a person can make an application for a parenting order, then the issue may be resolved, or they may find it overwhelming and they'd simply discontinue that application. And if there are no other parties left standing at the bar table, then the court will discontinue it. Occasionally, there will be other parties left standing at the bar table. For example, the respondent or an independent children's lawyer, and despite the person who applied for the orders asking for the matter to be discontinued, it is possible the matter will continue, as the court obviously can only make a decision that's consistent with the best interest of the child, and if a discontinuation is inconsistent with that, then that order won't be made until the court has been able to make a determination about the most appropriate order in all of those circumstances. Family law is federal jurisdiction and applies to all states except, well, it does apply to WA, but they have their own act. So it's federal, and that means orders made in the family court have application in all the states of Australia. All right, if I can go to the next slide. Care and protection law is quite different. As I think I said earlier, but I may not have, it's about a dispute between the state and a parent about what is safe with respect to the parenting of children. So it's not a dispute between two parents saying, is it preferable for this child to attend this school? It is a dispute between the state, DCJ, saying to a parent, we think your parenting is not acceptable. It's not a voluntary process, it's an involuntary process. So you don't opt in, or you can opt in, but the state's intervention is based on what they have assessed is risk to children. And if they've assessed the risk to children to be significant, they will engage a parent in the system. A parent can elect not to engage, but it does not stop the care and protection system from moving forward. So therefore, it's not a consent jurisdiction. You can't go to the court and say, oh, in some circumstances you can, and I can talk to you about those later, but generally you can't go to the court and say, oh, we've stitched up a solution that's going to meet the needs of this child. We think everyone's happy. Can you please sign off on that order? And the court's obliged to do it. That's not the case. The court must determine each case on its merits and make an assessment about what is consistent with the safety, welfare, and wellbeing of each child. Most significantly for our clients and for you as community workers, we need to understand that the care and protection system is not balanced in terms of power and resources. It is a parent or their family versus the Department of Communities and Justice. And it's not versus as in adversarial, but it is versus as in the resources of the state are behind the Department of Communities and Justice, justified, perhaps, and I think correctly, on the basis of the need to provide safety and protection to children, but they are overwhelmingly huge resources. They can access unlimited information, they can access extensive information about the parent and the child without the parent knowing. They have access to counsellors, doctors, support services. They have lawyers on tap. They have a range of historical information and documents that they can rely on to agitate what they think is best for a child, versus in some cases, a parent who is not literate, who is suffering from a mental health condition, who has escaped from domestic violence and does not have a home and has been asked to attend court and asked to make a decision in relation to the legal standing of his or her children. It's a big difference in power, and it is not surprising, therefore, that people either disengage from the system or engage with the system with some hostility. As a community worker, part of what I'm hoping to suggest to you is that we need to be thinking about those issues for parents and their children and think about how we can balance that power, not necessarily in terms of resources, but in terms of knowledge, skills, acceptance, dignity, respect, those sorts of issues. Care and protection system is based on the best interests of children, but they call it the paramount consideration is the safety, welfare, and well-being of a child, and that's supposed to guide all decisions made under the care and protection system under this law. And it's New South Wales based. It is true that you can register a care and protection order from New South Wales in the family court, and that can be recognised in other jurisdictions. But what that really means, and what I started this discussion looking at, is that Victoria has a different system. Queensland has a different system. New South Wales has a different system to Tasmania. And what that may mean for our clients who are transient is that they have to learn the language of each of those systems if their children are exposed to those systems in each different state. So it's confusing and difficult. And what might have been seen as acceptable in the Northern Territory, for example, may not be seen as acceptable in South Australia. And that's confusing for a parent because in a parent's mind, issues of risk, abuse, and neglect probably should be universal. I'm not sure that they are. Some of those issues are constructed concepts that develop over time as we understand more about parenting and children. But for a parent who was a consumer of the system and a child who is the person protected by the system, it's a difficult system to navigate if you're crossing state boundaries and very confusing. And I think we just need to be aware of that and use that understanding when we're engaging with clients as opposed to perhaps suggesting that they don't understand the risks or they lack insight into the system. If I could go to the next slide, please. So this is the principles for the administration of the Care and Protection Act, and those principles are found under Section 9 of the Act. And the most fundamental principle, which is, as I've already articulated, which is called the paramountcy principle, says that the safety, welfare, and well-being of the child or young person are paramount. And there's been some recent cases that have talked about this principle because in the past, the law and the focus of the court's attention has really been on making sure that children's safety and welfare is protected. And they haven't given, at least in the reported judgments, much consideration to the question of well-being. And well-being is really about if we place a child, for example, in an out-of-home care arrangement, what is it actually like for that child to live there? And there's a very interesting reported case where the children were given limited, or the agency supporting the children had limited money to support their food, was not enabling them to access allied health services and support services. And they were living a very, very meagre and unhappy life, notwithstanding DCJ was spending considerable sums funding their placement. The other really interesting question about well-being for children in out-of-home care who are living in non-family-based placements is that those children are removed from families who can touch and love them and share life stories with them with paid workers. And how does that, and it doesn't mean the paid workers aren't doing fabulous work with those children, but they are paid to be there. And how does that impact on a child's perception of their value in the community? And how does that impact on a parent's perception of their failure to attend to and meet the needs of the child, such that someone has to be paid to care for them in lieu of that child living in a family with their parent? The other interesting principle that I'll just draw your attention to is subsection 2(1), subsection 1(c). This is a bit of law talk, but what that principle basically says is that any action taken must be the least intrusive action consistent with the paramount concern to protect the child from harm and promote the development of the young person. So what that means is that if the state's going to intrude in the life of a child and their family, the touch should be as light as possible, so long as safety is assured. And so as community workers, we need to be thinking about that. How can we ensure that our intervention in the life of this family is as light as possible, but guaranteed to provide as much protection as possible to the child so that more restrictive interventions aren't required? If we could go to the next slide, please. So the objects of the Act are contained in Section 8, and these are interesting, and they guide the way that the Parliament, well, they guide the way that we should be interpreting the Act, because this is what the Parliament said the law is for. So I'll just quickly go through some of those objects. Section 8 says that children and young persons should receive such care and protection as is necessary for their safety, welfare, and well-being, having regard for the capacity of their parents or other persons responsible for them, and recognition that the primary means of providing for the care, safety, and welfare of a child is by providing them with long-term, safe, nurturing, stable, and secure environments through the permanent placement in accordance with the permanent placement principles. It says that those objects also say that institutions, services, and facilities responsible for the care and protection of children should provide them with an environment that is free from violence and exploitation, and provide services that foster their health, developmental needs, spirituality, self-respect, and dignity. And then I'll come back to that in a minute. But lastly, it says the appropriate assistance is rendered to parents and other persons responsible for children and young person in the performance of their child-rearing responsibilities in order to promote a safe and nurturing environment. So the objects of the Act really come into two major clusters. One, we need to provide support and help to parents to ensure that children are able to meet their potential. So that's why the department can fund early intervention services. That's why the department can support all sorts of community agencies to support children and families to stay together. And when they can't stay together, the agencies that are delivering services for those children, the agencies that are receiving government funding and have an obligation to account for the work that they're doing, must consider the developmental needs, the spirituality, the self-respect, and the dignity of those children. And they are just as fundamental as the objects of the Act as the other objects, which are protection. So part of what the government is saying is that we need to treat children as whole persons, not just clients for whom we deliver a discrete service. All right, I'm a bit slow, so I'll keep going as quickly as I can. If we go to the next slide. In about November 2023, the law changed. The law had changed earlier, but it became enacted and implemented in about November 2023, where the Parliament said, and this was in response to an inquiry into really the experience of Aboriginal children in the out-of-home care system. It's known as the Family as Culture Report. It's a report that it's long, but it's a very interesting and sad read. We've moved on from some of that, but the government has committed to implementing most of the recommendations of that report. And one of those recommendations is that it's not sufficient to provide basically lip service to the goals, objects of the Act, and the ideas of providing early intervention to families. So the concept of active efforts was introduced into the Act, and the court, in making orders for children, needs to take into consideration this concept. And the aim of active efforts or the active efforts provision says that, and it's section 9. Sorry, I had this looked up. 9A2, I think. Just bear with me for a second. I'll just check it. So it's, section 9, capital A, if you want to, it's there, if you want to look at it at home. It says, in taking action to safeguard and promote the safety, welfare, and well-being of a child or young person, there's an obligation to make active efforts to prevent the child from entering into out-of-home care. Okay, so firstly, active efforts need to be taken to prevent a child from being removed from the family. You can't just go and say, you're placing this child at risk, you need to stop this behaviour. You need to do more than that. And as a community worker, you will have a role in that. And then most significantly for me in my work, that for a child and a young person who has been removed from the child or young person's family, active efforts need to be made to restore that child to the young person's family. And where that's not practical, to place that child with family, kin, or community. And so what's new about that provision is that a strict reading of the legislation prior to the active efforts provisions being enacted really shifted the onus from a parent for whose child had been removed to demonstrate to the court that it was safe to restore that child, that as opposed to the department continuing to demonstrate why that child should not be in the care of the parent, because the parent needed to demonstrate, and still does, that they have addressed the issues that led to the removal of the child. Active efforts suggests that that's a joint enterprise, that the department also has an obligation to make an effort to ensure that that parent has the support that is required to ensure that the needs are addressed such that child can be safely restored to the parent. If we can go to the next slide, please. What that means in reality is that information, advice, support, guidance needs to be provided to clients by DCJ and community workers. That is both, it's timely, is practical, is thorough, is purposeful. So it's not just please go and do a parenting course, but your child is on the autism spectrum. We're going to refer you to this specific course that helps parents deal with young children on the autism spectrum as that diagnosis is emerging. That's targeted and address the risk. You have a mental health issue. We're not going to tell you to go and do a mental health assessment. We're going to take you to the doctor. We're going to ask the doctor to refer you to a psychiatrist, and we'll fund the psychiatric assessment. That's developed in partnership with the family and their community, and that's culturally appropriate. These are all parts of the equation for which community workers can actively participate. And if you're looking at these measures under active efforts, and these are in the Act, you can be thinking to yourself, what can I do to assist a client to undertake active efforts to address those issues? And is the department listening, or is the caseworker listening to me about what I can do? Actually, I preempted myself. If you go to the next slide, please. So used to be the question is, what evidence can you provide to establish that a child is at risk of harm? And now the question as a community worker could be, what needs to happen for that risk to be reduced, and how can you assist? Do the services exist? Are there barriers to access? Who else can be involved to assist that? And should you hold the caseworker to account if they propose something that's not practical, thorough, or purposeful? There's just a question here that I'll have a look.
Yeah, thanks, Daniel. I was just going to raise that with you.
Yeah, so the question is from, I hope you're okay with me using your first name, it's from Michelle, and it says, and what happens when the out-of-home care agency does not support the parent more than, please go and do a parenting course to assist in demonstrating change and getting back? Active efforts, what do you do when the caseworker is not listening? That's a fantastic question. So part of what you can do as an advocate in your role, depending on what your role is to advocate within that agency. But in New South Wales, at least, for primary care and protection matters, so these are matters that are first before the court, most of those parents, all of those parents are eligible for a grant of legal aid, and unless they've disengaged, most of those parents should have a lawyer. If you think there are active efforts as a community worker that could be undertaken, that are practical, thorough, and purposeful, but are not being undertaken, then I would reach out to communicate with the parent's lawyer, or communicate directly with the parent about what you think they could do to assist them achieve that outcome. It is very simple, and I need to say this to you, Michelle, it's very simple for me to say, oh, reach out and talk to a lawyer. I know that agencies have very strict policies about when you need to talk to a lawyer, and part of the problem with the child protection system is that agencies are funded by DCJ, and there are obligations in relation to those funding agreements that mean that it may not be appropriate for a junior staff or even a senior staff member to reach out to a client's lawyer. But what I suggest you do is identify what those support services are, try and identify how they're related to the risk, and try and communicate that in a way in which either the lawyer can be aware of it directly, or there's a record that you've made that attempt. Because, and I'll get to it a little bit later if we don't run out of time, at the end of, as part of the court process, lawyers will often subpoena records from government agencies and non-government agencies to determine why certain decisions were made that are relevant to whatever the court needs to do, and in this case, determine what a permanency plan would be like or whether restoration is viable. If you have a file note saying, I discussed with the caseworker that these were the risk issues and these were the ways to support it, then that lawyer will find that file note, and that we can then ask some questions of the caseworker in relation to that. The other thing is you can flag to a lawyer that there might be some information on the file that's worth asking for. So there are options, but it is difficult. mainly equipping a parent to undertake that work seemingly of their own initiative, so not without having been directed by the department, is often really positive and beneficial for lots of reasons. But for one reason, it demonstrates that the parent is committed to change and has insight into into the issues and how to change. So that's something to think about. Anyway, I don't have the perfect answer to that question. I hope that assists. Next slide, please. There has also been the introduction of the Section 12A Aboriginal and Torres Strait Islander principles, and these are the principles which are to be applied in relation to all Aboriginal and Torres Strait Islander children for whom decisions are required to be made under the Act. And I won't go through them in too much detail because they're pretty clear, but the focus for Aboriginal and Torres Strait Islander children is on prevention and the right to be raised in their own family, community and culture. There's a right for Aboriginal and Torres Strait Islander children's community representatives to participate in the design and delivery of services. And this has been rolled out. Some of these things have already been rolled out in DCJ. So before an Aboriginal and Torres Strait Islander child is removed in some regions, it will be statewide, I understand. They go to a special expert committee of community members who determine whether that is the least intrusive and most appropriate course of action. Child placement is to be in accordance with the placement principles, and I don't know if I talk about them, but basically Aboriginal children should live with family, and if not family, then people of their community, and if not with people with their community, other Aboriginal and Torres Strait Islander children, as long as it's consistent with their best interests. That parents and family members should participate in decisions, and that Aboriginal and Torres Strait Islander children and their families have a right to be connected to family, community, culture, and country. And non-Aboriginal and Torres Strait Islander people such as myself don't often understand the complexity of the differences between country and community. And it's important that we hear those voices from people from the community and themselves, and allow that to guide our decision-making rather than imposing our views. All right, if we can go to the next slide, please. There's some other relevant provisions that may be interesting for you, and to be aware of. They're not used a lot by community agencies, but you need to be aware that they're around. One of them is that the community is to provide services that promote raising children safely with families. So that's actually not that exciting, that interesting to you, but it justifies why DCJ fund a lot of agencies and a lot of parenting courses. The second issue is that, and this is becoming more and more popular, is that there's an onus in the Act for the early provision of dispute resolution. And dispute resolution is parties getting together in mediation, family group conferences, or other alternative dispute resolution models to try and resolve the risk issues and to try and lead family-centred decisions to reduce those risks. As I'll show you in a moment, there's a movement in early intervention towards trying to get those issues resolved informally through such processes. And as a community member, that's something you can be, or community worker, that's something you can be suggesting. And it may also be something that you can be supporting your client to engage with. Just because it is an informal and apparently flat structure, so everyone sits around a table and talks about what the risk issues are, that doesn't mean that it is a level playing field for your client. And it may be that you as a community worker are able to assist to support your client so that their voice is properly heard and that they feel like they were engaged in a process which can have a very, very long-term consequence for their children and for them. There's also provision in the Act, which you probably are not aware of, where a DCJ can request priority access to services. That's under Section 17 of the Act. So that means if a client, for example, needs to be entered into a drug and alcohol rehabilitation service that's funded by the New South Wales government, you could write to that agency, or you could ask the department to write to that agency under Section 17 of the Act to request that priority access be given. Section 23, this is unrelated, but Section 23 provides the definitions of risk of harm. And it's important that community workers are aware that they're not just limited to abuse and neglect, but are inclusive of the ideas of a failure to attain medical treatment, failure to go to school, exposing a child to a house where there's domestic violence, and there's also prenatal reports. And then the Section 27 talks about mandatory reporting. Just back to the risk of harm reports, it's worth having a look at the difference between or those issues. And if you're working with clients in community and you see them engaging in behaviour that may result in a report, talking to them about that and why that might be of concern. Part of my role as a litigation lawyer in care and protection is to participate in the children's court when there are applications by the Department of Education for compulsory schooling orders, and that's when children are refusing to attend school and the court intervenes. But that's another reason why DCJ may also get involved. So there's consequences in relation to seemingly unrelated aspects of a child's welfare and development that may expose a client to the child protection system. And when that does happen, the Department of Education's approach is not necessarily the same as the Department of Communities and Justice's approach. And what both of those approaches ultimately often end up clients doing is withdrawing from the system and disengaging. All right, we'll go to the next slide if we could, please. Early intervention, most early intervention is about preventing the need for a child protection report to be made. It's about educating children and their families about safety, welfare, and well-being. It's about providing support, and that support being targeted. It's about looking at your clients and thinking, what are the risks for this client? What can we do to ameliorate those risks and divert them from a child protection report being made? The sort of people we mostly see, and I'm sure the sort of people you mostly see, are people who are struggling with issues with mental health, domestic violence, drug and alcohol misuse, and overwhelming poverty. It's interesting though, because there's no empirical reason why why people of higher economic status don't subject their children, or are not part of the child protection system, saving the fact that they have the social skills and the invisibility that enables them to navigate the system in a way that means they're not exposed and directed. I challenge you to think about that, because we know about the statistics with respect to domestic violence, and we know about the statistics with respect to child sexual abuse and probably physical abuse. But when I'm in court, most people at that table, even if they weren't all eligible for legal aid, even if they didn't want to receive legal aid, are all eligible for legal aid. It's a very different picture in the family court. Yet some of those risk issues are still apparent, but there is no DCJ. So we need to be thinking as community workers, why are our clients so visible, and why are we only looking at these clients and not other clients? Does it mean that these clients are placing their children at more risk of harm, or does it mean that the system has some biases in it, which means that particular groups of people are more likely to be captured by the system? And if you come to that conclusion, what are you going to do about it? What does that mean? I'm not suggesting you don't take any action, but I am suggesting you may need to think about it. Once the report's been made and the department has assessed that report as requiring a response, our client and their lives come into focus. So sorry, back at early intervention, the department shouldn't be involved. A report is made and suddenly it's all about the parent and their child. DCJ will gather information from external agencies using their extraordinary powers under Chapter 16A. Our client and their service providers might be interviewed, and they won't know what to do in relation to those interviews. Do they tell the truth? Are they completely candid? Do they refuse to engage? Every single one of those options may have negative consequences for them, or may result in a really positive outcome. Their children may be interviewed, but what if they don't want their children to be interviewed? What are we going to do about that? What if they interview their children at school and they don't know? And then decisions are made, often by people they don't know, about what further action to take. Can we go to the next slide, please? Early intervention is a critical time for clients because decisions need to be made about the risk, how great that risk is, and what needs to be happen for that risk to be reduced to an acceptable level. And the price for all participants, and price is probably the wrong word, but I've used it there. The price for all participants in making a decision that is not correct is incredibly high. So there's a lot of pressure on parents for making a correct decision. Do I engage? How do I engage? There's a lot of pressure on the children to work out how they're going to work with the department to navigate this system. I want to be safe, but I don't want to be removed from my children. How am I going to do that? If I tell this to this person, what's the consequence for me? And there's an incredibly high burden on service providers and DCJ, the delegated officers, to make the correct and preferable decision with respect to risk, because the consequences of making the wrong decision are, or media criticism, but really significantly, and their real concern is child significant harm and child death. But for our client, a reaction to an intervention is a trauma-based reaction in many cases. So that reaction might be, I'm going to fight you all, I hate you, I'm going to get you, this is all crap. Or it might be flight, I'm not going to talk to you, I'm going to walk out. It might be freeze, can't engage. Or it might be kind of fawn, which is a new concept to me last year, but it's that acquiescing to the department, being super nice to them and super cooperative, but actually not believing in what they're saying. All adaptive responses to a trauma. The trauma is someone's telling them that their children, something that they value, something that is important to them, something that possibly gives them meaning in their life, is under threat. Next slide, please. Unless a child is at imminent risk of serious harm, removal is generally not considered an option. So children will be removed, but generally it's a last resort option, and it's based on whether a child is at serious risk of significant harm. A trauma response to the department's intervention can turn a low-level acceptable risk into a risk of serious harm. So the department comes and knocks on your door, you grab the kids and run away. That may turn the child into a serious risk of significant harm because DCJ are unable to assess the risk, and they will be required to err on the side of caution. And as a result of that, they may need to take the children into care, and that will reveal a whole lot of other factors that the parent may be uncomfortable with, and set up a dynamic between the parent and DCJ, which is not necessarily in the best interest of the children. So as service providers, we can help clients to understand the role and function of the department. You're not asking them to agree with it, but to agree that they have a job to do, and it is a job. It may not be personal, and if you can encourage clients to see the role of DCJ in a professional way, that you have a working relationship with them, that may be more helpful than for them to personalize the outcome. But it is really personal for a client, and we can't dismiss that, but we can help them to navigate that or work through that. To help the client to understand the risks and to articulate insight into the risks. So part of what a client's going to be required to do when they engage with the department is to say, I know that when I use ice, I'm unable to parent. I want to be able to parent, and therefore I understand there's a connection between my capacity to parent and my ice use, and I need to do something about my ice use, for example. And if they can articulate that to the department, and then they can follow up on their understanding, they're on the pathway to a safety plan being developed that enables those children to remain, or if they've been removed, for a plan to be developed for those children to be restored. One of the things you can do really well as a community worker is take care with your record keeping. So if those records are subpoenaed, and they might not be subpoenaed just by the parent's lawyer, they may be subpoenaed by the department or requested by the department, those records can have a really damaging impact on a parent if they're carelessly recorded. So it might be, and it happened to me, client attended the contact visit smelling of alcohol, okay? And that's what the sensory perception of the contact worker was. I'm not saying that that was incorrect, but the issue for my client was that she had infected gums, she was meeting her child, and she had mouthwash. The second part of that explanation wasn't in the subpoenaed record. So my client had to then prove about that she had infected gums, that she'd used mouthwash, etc. Careful record keeping, giving the client the opportunity to explain a negative outcome might be helpful. And also be aware that, for example, at a contact visit, you're taking notes about every part of that contact visit. So try and put yourself in the shoes of the child and the parent. There are going to be times when it doesn't go well because they are children and they do things that can be annoying. And if we're recording that in the most negative way possible because we have an agenda, that's going to do harm for the long-term understanding of that family. And it may not be an accurate reflection of what's happened in the whole life of that contact visit. Just something to think about. Help balance the power differences. So if you think your client doesn't understand or can't engage because they're frightened of attending the Department of Community Services office because that's where their child was removed and it's a site of trauma for them, talk about that with the Department of Community Services. Talk about other options. Talk to your client about what they can do to manage that. And help the client to understand and engage with the department. The quickest and easiest and best way for a parent to get a child returned to their care is for that to be recommended by the Department of Communities and Justice. Dragging it out through the court, fighting about it, having to prove every point takes time, causes emotional energy and strain, and leaves permanent marks on families and children. So if they can work with the department, understanding their role and agenda, understanding that they are fallible and make mistakes, but that's forgivable in the circumstances, you might be able to get an outcome that is appropriate. I'm not suggesting that we are an apologist for the department, but if clients can understand their role and function, they're likely to get a better outcome. Next slide, please. So there's lots of different options to removing a child. Those options can include temporary care agreements, which is an agreement entered into voluntarily by a parent and DCJ, where a child's care responsibility is assumed by the department. They are available for 2 lots of 3 months within a calendar year. And the aim of a temporary care agreement is to address why a child might be in need of care and protection. If at the end of the temporary care agreement, the child is still considered to be in need of care and protection, DCJ then need to seriously consider about whether a different form of order or application needs to be made to the court. A parental responsibility contract is not a removal. It is a formal document that can become evidence in a court case of what the parent agrees to do and what the department will do to support a parent. So parental responsibility contracts can include and items such as the parent will attend rehab, or the parent will agree not to allow a certain person to come to the home. The parent will, often they say this, enforce an ADVO where they are the person in need of protection. The parent will attend upon counselling. Part of your role as a community worker is you don't need to be a lawyer, but it's good to be a lawyer, but you don't need to be a lawyer to read those documents to say, is this realistic, achievable, and knowable? Does my client know what they're expected to do and can they do it? So if the child's supposed to go to daycare every day, but my client has to catch the bus and that takes 3 hours, is that reasonable? Do I need to talk to the client about that? Do I need to talk to the department about that? And should I be thinking about whether this client needs to have some access to some legal advice? A parental capacity order I have not had much experience with. There were orders that were designed to be brought in to encourage parents to do parenting courses, drug and alcohol counselling, domestic violence counselling, by order of the court, even if they didn't agree. I think the jury's probably out about those. I haven't seen many of them, as I say, and if a parent's going to agree to a parental capacity order, do you really need one? A Section 38 care plan is a care plan which can reallocate parental responsibility for a child to another person by consent. They are made as orders of the court, and the advantage of a Section 38(3) care plan is that to change the legal arrangements for a client's or a family's parentage, the court is not required to make a decision that a child is in need of care and protection, and nor is the court required to make a decision that there is no realistic possibility of restoration of a child to the care of a parent. They're 2 very, very important and foundational legal concepts in the Care and Protection Act that have long-term consequences for parents in relation to the future of a child. So a Section 38 care plan means that those foundational legal concepts don't need to be established, and you can move on to actually what you want the court to do, which is to make an order that either changes parental responsibility for a child or something like that. So just to give context to that really quickly, if a parent is really struggling and they want their parent to have decision-making responsibility for the child, rather than a whole court process going on, you could change that parental responsibility at law, either through the Family Law Act, which is a probably preferred option, or through the Care and Protection Act under Section 38. There are a whole range of other plans and arrangements that a client may be exposed to on their journey, on their early intervention journey, including safety plans, family action plans, family group conferences, which we've talked about, and a referral for some action under the Family Law Act. All of those options, a community worker doesn't need to know in detail, but needs to consider talking to a client about. So part of what a community worker can do in engaging a client is to think about, actually, it looks like the department are going to intervene. Can we talk about different ways for this problem to be resolved? Have you thought about asking your mum to take responsibility while you get through this difficult path? Have you thought about having a little break in a mental health facility to let you get yourself together? Maybe a temporary care agreement might work. All right, next slide, please. You may be saying to yourself, oh, it's really easy for a lawyer to talk about all these legal options. What are we supposed to know all this? And the answer is no, not really. There's lots of different ways your clients can get access to early intervention legal advice. The most significant way now is what's called the Legal Assistance for Families Partnership Agreements, or otherwise known as LAFPA. That's an agreement that's brokered between the Department of Communities and Justice, Legal Aid New South Wales, and the Aboriginal Legal Services. And the aim is for every parent to be offered the opportunity of a referral for early intervention legal advice. And if they consent, for legal aid or ALS to reach out to that parent to at least provide them with some early intervention legal advice. So there's plenty of, so that should come from the DCJ perspective, but from you as a community worker, there's also the Legal Aid's Early Intervention Unit, which is a standalone unit which can provide care and protection advice to parents anywhere in the state. There are community legal centres, and there is legal aid officers in most, sorry, I just got an email coming that distracted me. There are legal aid officers in lots of big regional centres who also provide advice and assistance to clients. It is not an admission of failure or admission of a legal issue to seek legal advice when interacting with DCJ. And we would suggest that legal advice is really the most appropriate option, and one of the things that you can really encourage a client to do. Legal advice does not necessarily mean challenging the department. It may just mean explaining why the department are doing what they're doing and what you should be doing or considering to do in response. Next slide, please, Scott. Okay. So as a last resort, children are removed. They could be removed with a warrant, which means that a delegated officer from the Department of Communities and Justice has approached the local court and asked for a warrant to remove a child, or more commonly, they're removed without a warrant because they're at immediate risk of serious harm. If a child's been removed, then the department has to, within 7 days, 3 days, sorry, I think it's 3 days, they don't comply with this. It's 5 working days, approach the court to explain why they've removed the child and they've not taken any further action, or make an application for a care order. The application for a care order is generally what's known as an application under Section 61 of the Act, which is an application for a long-term order. But there are other, you can go to the next slide too, please, thank you. There are other applications that could be made, which include an emergency care and protection order, and they have different tests. And the Care and Protection Act provides for removal and also care of the child pending removal and care of the child after removal. So if a child is removed and before the child is brought before the court, the Department of Communities and Justice assumes care responsibility, but not parental responsibility for the child. And what that means in reality is that they are able to make day-to-day decisions to ensure the child's needs are met, but not major decisions such as, oh, this child can go to this particular school, or we're going to enroll this child in counselling. Those decisions are more major long-term decisions which fall within the ambit of parental responsibility rather than care responsibility. Next slide, please. So generally, if a child has been removed, generally the matter will be listed in the Children's Court within 5 working days of the removal, and the department will provide the client, the parent, with a form called Application Initiating Care Proceedings and a massive bundle of documents. Those are not sworn documents, but they're the evidence the department will rely on. So the application goes into court and the bundle just tells the parties this is our evidence. Often, DCJ will ask a parent to attend their office for the purpose of being served with those documents. I think that that's really problematic. And I think as a community worker, if you are aware that the department is going to do that, you may want to challenge them or talk to them about maybe being more trauma informed in the way that they do it. Sometimes they have to do it that way because the parent is aggressive and people are should not be put at risk. But asking a parent to attend upon an office to be served with papers that remove your child is really, really confronting and really, really sends a message to a client that their value in this system is less than what we would think it should be, in my humble opinion. So they'll be served with that document. That document will tell them when the court date is likely to be, and they will no doubt be overwhelmed. And as a community worker, one of the things you can do is assist that client to do two things. One, to not be overwhelmed by saying that there is help on the way. That help is in the form of legal advice and also your advice and support. And two, to say this is the beginning of a process, not the end. So it's really important that parents and children, if you're working with children, are aware that just because an application has been made doesn't mean that they're in care until they're 18. It's the same with an adoption, but I won't talk about adoptions because we don't have any time for that. But when they first receive that document, they will read all this information about them that they did not know and with which they may not agree. They will have the opportunity to respond to that document, but it may not be timely or appropriate for them to respond to it on the first occasion it's at court. Can you go to the next slide, please? And it's just a fairly blank slide. Normally what happens on the first occasion, if a child has been removed, is the Department of Communities and Justice is asking the court to make an order that allocates parental responsibility to the department, called the minister, on an interim basis. The test for that, and it's a very easy test for the department to satisfy, is that it is not in the best interest of the safety, welfare and well-being of the child to remain in the care of their parents. I'll just repeat that. It's not in the best interest of the safety, welfare and well-being of a child to remain in the care of their parents. So when the court is looking at that test, the court has to look at the evidence before it. A parent has just been served the day before at the DCJ office, probably at 5 o'clock, with an application initiating care proceedings and a huge bundle of documents. They're trying to read those documents, but they are so distressed they can't read them. They're at court 9 o'clock the next morning and they have to answer that application. Every other person there has had the opportunity to read it with a calm and cool head, but they haven't. They will have access to a lawyer, and it depends where you're from, but in most major children's court centres, there is a duty scheme where every parent is represented by a lawyer and each child is represented by a lawyer. If the children are under 12, they'll be represented by the same lawyer. If the children are over 12, they will have a separate lawyer each. On that first occasion, it's exceptionally overwhelming for parents. They will be angry, they will be frustrated, they will be overwhelmed, traumatized, I think is the best thing to say. And they're going to be asked to agree that it's appropriate for the court to make a short-term order, which means they don't have the right to make decisions about their children. They'll get legal advice about that option. And if they haven't got legal advice and you're a community worker supporting them, you should ask the matter to stand down if you can and join them in court and ask to speak to the magistrate if you have to say they haven't had legal advice and they really need that legal advice. The magistrate may or may not adjourn it to enable them to get legal advice. But usually what they may do is, if there's a lawyer available, they'll adjourn it to enable that to happen. If there's not a lawyer available, they may adjourn it, make a short-term order that's time limited, which means it will expire, and then enable them to get legal advice. The issues for you as a community worker is that there's a couple of things a client can do at that time. One, they can go through the material in a lot of detail and find out all the mistakes that DCJ had made and provide their own version, and that's really important. But most importantly for them, they need to think about decisions about who else could care for this child if I can't while I'm gathering my evidence. And if there's a family member or a friend or a person in the kinship network who is easily able to be assessed by DCJ and is likely to be accessible, then they should be nominating that person straight away. DCJ should have asked them, but if they haven't, they should be nominating that person straight away. And it's really important for a child to be placed with kin because it means that contact can be flexible and frequent and can hope to achieve the aim of not breaking the connection between the child and the parent whilst the matter goes before the court. So yes, your parents will want to focus on all of the misinformation that the department have perhaps put before the court, which may or may not be misinformation, but from their perspective clearly is. But the other issues are those issues. Who can provide care if I can't? What sort of contact can I ask to have? And then the other things that are really helpful for a client at court is to think about, my children are distressed, they've been removed from me, I know them best. What would they need from me to give them some comfort? And so can you identify their favourite toy? Can you connect them with a friend or a family member who should know them and talk to the department about reaching out to those people? All of those issues, that if a parent can show child focus, will assist them in the long run to show the court that this child should be restored to the care of the parent. Next slide, please. The next slide has this confused woman on the screen saying establishment. Establishment is a term that care and protection practitioners use and the Children's Court uses to describe the court making a finding that a child is in need of care and protection. The court is unable to make long-term orders unless it makes a finding that a child is in need of care and protection. And so that finding establishes the power of the court to make long-term orders. All right. If the court is unable to find that a child is in need of care and protection, then the court will dismiss the application and there is nothing before the court and the matter is finalised at that first or that second occasion. The issue with establishment is that the onus really is on the secretary to demonstrate that a child is in need of care and protection, but they're demonstrating that a child is at risk. And it's very difficult to say that a child is not at risk in the circumstances that usually bring these children before the court. So what parents may say is, yes, I admit there was some violence in my home, but the child wasn't exposed to that violence because they were in another room. Okay, and what we know that the research in relation to domestic violence would suggest that child is clearly at risk of the effects of domestic violence. It's hard for parents to understand that concept, and if you try and challenge establishment, you normally can only do it on a factual basis. So they've got it wrong. For example, I've had a case where the department alleged there was domestic violence in the family's household because it was reported by an ambulance officer as something that they saw the consequences from. But we had 3 independent witnesses who said, actually, that's not what happened. This is what happened. And they were independent witnesses. And so we had a hearing on that case and the court found that the evidence of the independent witnesses was more reliable in this occasion than the ambulance officer who only saw the effects of it. And the matter was not established because there was no risk. But that's rare. Most cases are established and most parents need to not spend significant time stressing about that, but it's hard. That's something where you as a community worker should be thinking about, how can I support the client to talk to the parent? How can I support the client to talk to a lawyer to talk about these complex concepts? And part of it is you understand those concepts. So when they walk away from their lawyer, they can ask you the questions they didn't seem to ask the lawyer. I'm going to rush through the rest of this presentation. Even though we extended, it's still lots to go. Okay, so can I go to the next slide, please? Only people entitled to participate in care and protection proceedings are the parties, and the parties to the proceedings are the minister, each parent or person who holds parental responsibility, and a child representative. Other people who are interested in the proceedings can ask the court to join the proceedings, and there's a particular process that needs to go on. A person would ask the court to join the proceedings in circumstances where they've asked potentially to be assessed as a carer or they've asked to have contact with the child and the Department of Community Services have refused to assess them or have provided them with a negative assessment. In those circumstances, it may be appropriate for an external person to seek to be joined to the proceedings. It's not a right. The court will consider whether they have a significant interest in the child and whether the court should exercise its discretion to join them. Part of what the court will take into consideration is what they can offer and how much delay and how it will impact on the proceedings. Next slide, please. Children, as I've said before, under 12 will be represented generally by an independent legal representative who acts in their best interest, and over 12 will be represented by a direct legal representative who acts on their instructions. As a community worker, if you're working with a child, it's really important that they have access to their lawyer. And if their lawyer hasn't reached out to them, there's nothing to stop you reaching in to their lawyer to say, hey, this kid wants to talk to you. The lawyer may choose not to speak to them. If they're a direct legal representative, that would be wrong. But if they're an independent legal representative, it may be appropriate depending on the circumstances. Lawyers should meet with their children unless there's a good reason why. And that good reason may be that they don't have the capacity because they're a newborn baby, or because it might be damaging for them. But that's something they should be communicating with the worker who's working with that child. And you would hope that a children's lawyer reaches out and spends some time talking to people delivering services to that child. All right, next slide, please. The placement stage is really the heart of care and protection issues. It's the stage where the court decides whether a child, having been removed from a parent, is to be returned. And the questions the court has to answer is, has the parent addressed the issues that led to the removal of the child? If so, what are the circumstances of the child? Or can that parent address those issues within a reasonable time? Has parent permanency planning been adequately and appropriately addressed? Do we need more evidence about those issues? And what should the long-term plan for the child's accommodation, parental responsibility, contact, religion, schooling be? Those are all issues that happen at the end stages of proceedings, and they're all issues where parents should be actively involved in decision making. Next slide, please. What can you do? If a parent's seeking restoration, they'll have to show the court that they've addressed the issues that led to removal. And they have to show the court, because normally you don't just restore a child and walk away. They have to show the court that they're able to engage with services so the court can have some comfort in relation to trusting, I know that that's a poor word, but trusting them to have the child restored to their care. So if you're providing a service to a client with a matter before the court, an issue, some of the issues can be, has the child attended that service? Did they benefit? Has there been a change? And there are things that you might be asked to give an opinion on. And giving that opinion, think about the context of why you're giving that opinion. You obviously have to give an opinion that's true and correct and truthful, but you don't want to be anybody's puppet. So you don't want to give an opinion just to suit the needs of DCJ, and you don't want to give an opinion to suit the needs of the client. You just need to be aware that that information may be critical. Think about how you're going to develop a therapeutic relationship with your client in the context of litigation. Is the information you're providing within your area of expertise? So, they have a mental illness, but are you qualified to say that? Are you seen as independent or aligned with the party? What does the client think? Do they know you're going to do this? And are you able to provide a letter of support or a report? Because the client may need evidence, and that's something you can do. Next slide, please. So as I said before, the client can access legal representation through our duty scheme, which is almost every client will have access to a duty lawyer, which is on the first occasion of contact. They are eligible for ongoing representation through a grant of legal aid, and there is no means or merit test for parents for a grant of legal aid for care and protection proceedings until the final plans develop, the care plans develop, which is that permanency plan I talked about in the slide previously. And then legal aid will assess whether the parent is likely to do better than what is proposed under the care plan if the matter's gone to hearing. And if not, legal aid won't fund a hearing, but that doesn't stop the parent getting your support and running a hearing themselves. Next slide, please. Okay, so final orders are made, and often or sometimes those final orders are going to be made which say that the child can't be restored to the care of the parent. Okay, it's important to acknowledge what's happened for the client. They will have not only the trauma of removal, but the trauma of attending court, being disempowered in court, not really understanding what's happened in court. Even the best lawyer can explain to a client what's been going on, and the client may not be able to receive that information because of their trauma and the heightened emotions of what's at stake and what happens at court. It's not necessarily the best time to talk to them about what needs to happen for them to get this child back, but you need to flag for them that that discussion should happen soon. So you need to plan moving forward about when the client's ready to make the changes they need to make. Clients don't need to feel accountable to their lawyers or service providers. It's really important that they don't feel like they've let you down. They need information about the next steps in the process, but they may not be able to receive it. And they need a connection to service providers, but they also may just want to go and do as many drugs as they can to blot it all out. So these are the dilemmas you will face in providing a service to a client. And what you need to do is be aware of it and give clients space and guidance and information. Next slide, please. So once final orders have made, there's lots of different options that a client can have. Those options are not simple and they're not emotionally easy. Issues that arise for clients are that they're not having, their contact might be reduced and the quality of their contact might become average or poor. They're not getting information about what's happening for their children. The children are calling someone else mum and dad, and they're continuing to be subject to oversight by the department, but they don't even have their children in their care, and that's really problematic. So that's what our clients are looking at. It may be an opportunity. Sorry, next slide. It may be an opportunity for our clients to consider taking the matter back to court after they've had time to process the trauma of the case and they're ready. To do that, they have to ask the court for permission. It's not simple. So often you might hear clients talk about, I'm going to make a Section 90 application because I've changed. It's not as simple as that. The court philosophy and the legislative scheme provides, I'll go as quickly as I can because I want to give you 10 minutes for question. The legislative scheme provides that children have a right to permanency and parents don't have a right to keep on bringing applications back to board before the court. Those applications need to basically be in the best interests of children. And to do that, the parent needs to get permission from the court, and to obtain that permission, they need to demonstrate that there's been a significant change in a relevant circumstance. And the court needs to take into account primary considerations, which are the child's view, the length of time the child has been with the current carer and whether that placement is stable, and the least intrusive option in the life of that child. So they're the primary things the court needs to think about. And then the secondary things are, how old is the child? What's the proposal? Is it reasonably likely to be successful? What's important when you're thinking about talking about Section 90 or request to vary an existing care order with a client is that even though they've changed, it may not be in the best interest of a child to return to the care of a client. Even though they have other children in their care, it may not be in their best interests. And that's because the circumstances of the child mean that their settled arrangements in the care of their current carer are less intrusive than risking changing them to be placed in the care of their parent. There is no right for a child to grow up in the care of their parent after parental responsibility has been reallocated. What that means for you in providing guidance, information, and support to clients is you need to be aware there is a window of time where a Section 90 will be viable, an application to vary an order will be viable, and there's a window of time where that viability will close. So if a child has been living with a foster family for 7 years, unless that placement is not stable, it is very difficult to demonstrate to the court that it's in the best interest to remove a child from somewhere they're stable to somewhere we do not really know. So clients need to be encouraged to take their time to grieve the loss of their children through the care proceedings, but not too much time. And sometimes community workers might need to provide a space for those clients to revisit those issues again and again within the first 6 to 12 months after a final care order has been made. Next page, please. And there can also be disputes about contact. And if a client has a dispute about contact, they can do a contact mediation, or you can make an application to the court after final orders for contact orders. Generally, we would advise that you would refer a client for some legal advice about a contact issue, because we can often negotiate with DCJ or the non-government agency providing support to the child and the foster family or the kinship family to increase contact and to work out the issues with respect to contact. And those negotiations are quite productive often. All right, and then look, really lastly, last law of advice is that if a care order has been made in under a welfare legislation, you can't make an application to the family court for a different order unless you get permission from the department. So you just need to be aware of that. So sometimes what happens, the care order has been made, placing the child in the care of the grandma, and the mum's sorted out her staff and she wants to come back and they want to make an order under the Family Law Act. You can do that, but you need permission from the department. under Section 69ZK, and there's a process that you need to go to. Again, it's just a trigger for you and that client to reach out in partnership to a legal assistance provider to get some legal advice on your options. Okay, so what can you do? You can advocate for the client, advocate for their dignity, for their well-being, for their respect, advocate that they are people who have suffered trauma and who love their children but may not be able to care for them. You can help them get access to legal advice. You can help their legal representative provide them with the best legal representation possible by guiding them about issues that might be complex or difficult or ignored by their lawyer. Lawyers don't have a lot of time. They're often on a grant of legal aid, which is very limited in time and very limited in scope. If you can provide their lawyer with tips and tricks, if you can get them to the office on time, if you can assist a client to draft some evidence, do so. Also, you can provide your own evidence. If you've been providing care or a community service to a client and it's within your agency's guideline, provide a letter of support. Be prepared, though, that someone may ask you to answer to that letter of support, and you may be cross-examined on it. So you need to do it honestly and openly. Don't put in the letter of support information that's not helpful, which is opinions for which you're not qualified to make. And like, I think she'd be a great parent, even though you haven't seen her parent, but she has engaged with my service. She appears to understand the primary principles of parenting or whatever the issue is. Next slide, please. Community workers have a vital role to play in the process, the care and protection process. The best outcome for a client is a trauma-informed collaboration with that client to understand the reasons why the Department of Community Services and the welfare system is involved and to engage with that system. When you say things like a client failed to engage, is that what you mean? Or do you mean that we were unable to find a way for that client to engage in a way that they were comfortable? If that's the case, report it that way. Do you really mean that a client didn't have insight, or do you mean that the client was unable to articulate in language that we understood what their thinking was with respect to the risk issues? Clients need your help to access services and to get evidence, and where possible, please give them that help, because that will help them provide to the court the best evidence possible, which hopefully will lead to the best decisions being made. And think about what we can do to help clients focus on what the system is trying to achieve, the protection of children. And so it's about getting them out of that, if you can, getting clients out of the mindset that this is all about me and getting them to focus on, this is about the protection of children. I have a valuable role to play in that. Here's how I can demonstrate to the court that I can attend to and meet my children's needs such that they are safe and safe enough for the state not to need to intervene. I'm sorry I rushed the end. I thought we had much more time, but we didn't. I'm open to any questions. And thank you for staying for so long.
Thank you, Daniel. Just wait and see if the audience have been listening and waiting to ask questions. Just wanted to also let people know I emailed a PDF of the presentation just shortly prior to the webinar, and I have also uploaded it into the chat. Chat is disabled for you to ask questions, but you should be able to download a copy of that handout from the chat.
No questions?
No, it's just some. Oh, hang on. Yes, there is from Vanessa.
I didn't see that. Aside from legal aid and 2 sets of community. That's a good question, Vanessa. Look, there are, except I'm probably not the best person to tell you what they are. There's an initiative of peer support being provided for parents in care and protection proceedings. It did run out of Broadmeadow Children's Court, and it might be, if you're interested in that, something that you want to contact either Newcastle University or look up peer support for care and protection. So there's a few peer support groups, and they're fabulous because they're people who've been through the system supporting other parents who are going through the system. So that's really good. There's a lot of peak bodies that also assist families in relation to care and protection issues. So there's SNAKE and there's the child protection peak bodies. And DCJ has carers groups as well that can also provide information and support. Usually locally based agencies and systems are best because they know the workers at DCJ, and lots of the outcomes are based on relationships. I know that sounds terrible, but these are people talking about risk. And if you can develop productive and respectful relationships with all players in the system, you're likely to get to the real issues and likely to have help resolving them. I hope that helps you, Vanessa. But yeah, there are some supports. Thank you, Ellie. Can you, Tori, can you tell me what NFP stands for?
Not-for-profit.
Advocacy group. What can we do to help families? Sorry, that's just, what can we do to help families? I guess I don't have the answer to that question, but I think that if we can treat our clients with dignity and respect, understand that they are suffering, that the process is traumatic, but they have to deal with it, and helping them to navigate it in a space that is safe for them is the best I think you can do for family members in the community. The other option is to get more people to put their hand up within people's family networks to provide care so that the clients who've had their children removed have many more options. And I guess if you have issues with the way that government and non-government agencies are providing services to families and children in care, speak up about them. Talk to your local MPs and talk to the department complaints bodies, because things are changing, but they need to continue to change, and people need to be accountable, not in a negative way, but because children are so important and there's so much at stake, we need to make sure we do the best for them. I hope that helps. But know your local groups and local support services. There's fantastic local support services in different communities, lots of restoration service providers, and DCJ have good support, good community information pages on their website.
Just this, Manali has raised their hand, but we're not able to take audio questions. So if people are able to type questions in, that's the only way that we can take them in the way that our system is set up. Lots of nice feedback from people. Daniel?
I'm sorry to everyone that was so long, though. I said we'd have a break, but I didn't even notice the time. So I don't know how to do this. I probably need the whole day, or it's too ambitious. But thank you very much for your kind words.
Oh, sorry. Yes. The webinar is being recorded, and I will provide the link to the recording in an email that you'll receive automatically from Zoom within a day. It's usually a day after the webinar you get the email, and we'll put the link to where you can locate the recording in that email. So thank you for asking that. I should have mentioned that at the very beginning. Okay, so we've reached the time. Thank you to our audience, and thank you so much, Daniel, for the presentation. It's a big hour and a half for you to be speaking the whole time, but people have really appreciated the information that you've shared. So thanks, everybody. Thanks for joining us, and we'll say good afternoon now.
Thank you all, and I wish you all well. See you.